Hello everyone, my name is Charles Mack. Today, I will address crucial questions in the range of international finance. What is the most effective approach for reforming framework governing sovereign debt restructuring to ensure resilience and fairness? My paper titled Evaluating Reform Proposal in Sovereign Debt Restructuring, A Path Towards Resilience and Fairness seeks to answer these questions by critically assessing various proposals for revamping the sovereign debt restructuring framework. By examining these proposals, my paper aims to determine the most promising approach for developing a comprehensive and effective sovereign debt restructuring governance framework. The issues of sovereign debt restructuring is as old as the concept of sovereign debt itself. Adam Smith in 1776 argued that a state declaring bankruptcy should be fair and transparent as when the individual does so. However, unlike domestic bankruptcy regimes, there is no international insolvency procedures for sovereign debt restructuring. Sovereign state can never go bankrupt, as the liquidation process used for commercial entities does not apply for the state. These unique characteristics contribute to the absence of streamlined international procedures for sovereign debt restructuring, leading to a fragmented and insufficient framework. The current framework governing sovereign debt restructuring suffers from numerous issues, including limited enforceability, power imbalances, and insufficient representations, and outdated institutional structure. These problems result in disagreement, high cost, and uncertainty, which undermine the validity and equity of the sovereign debt restructuring process. Consequently, there is pressing need to establish an ideal sovereign debt restructuring governance framework that addresses these challenges and foster the international collaborations and economic stability. My paper evaluates three approaches to reforming sovereign debt restructuring framework: the centralized statutory approach, the decentralized contractual approach, and the modular approach. Each of these approaches offers distinct advantages and drawbacks, which I will briefly summarize. The centralized statutory approach advocates for a unified centralized mechanism administered by an international authority, legally binding all parties in the process of sovereign debt restructuring. This approach used traditional hard law treaties to govern the sovereign debt restructuring framework. However, previous attempts at implementing such a framework, for example, the IMF's sovereign debt restructuring mechanism, have failed due to the political impracticality. The decentralized contractual approach focuses on improving and modifying the contractual terms of sovereign debt contracts to reform the sovereign debt restructuring process. This market-based approach includes initiatives like introduction of collective action clauses, which allow creditors to agree on the debt restructuring even if some creditors are opposed. However, this approach also faces limitations, as stabilizing financial and monetary system through contractual modifications alone is challenging. The model law approach, which falls between the centralized statutory approach and the decentralized contractual approaches, offers a more flexible solutions. Model law are not binding, allowing for adaptability to specific situations. This approach has the greatest potential for establishing an effective sovereign debt restructuring framework, and it balances the need for cohesive governance structure with the flexibility required to accommodate diverse sovereign debt context. And in conclusion, among these three approaches evaluated, the model law approach emerged as the most effective for improving the sovereign debt restructuring framework. It permits sovereign states to unilaterally change or renounce agreement without violating international or domestic law, and includes private sector creditors often overlooked in other approaches. Nevertheless, the model law approach is not without the shortcomings. It can be too vague for parties to rely upon in the sovereign debt restructuring process. Therefore, my paper suggests adopting a unique international solution combined elements of the centralized statutory, decentralized contractual, and model law approaches to create a resilient and fair sovereign debt restructuring framework. And thank you very much for your time, and I hope this summary has provided you with a valuable insight into my paper on the sovereign debt restructuring. Thank you so much.